Good morning, everyone. I hope everybody had a great week and their new year is starting out really well. Today, I just have a few kind of pickup things I want to discuss with everyone, just to make sure everybody stays compliant with what is needed for the SkySlope files and our files and for sign-off. So again, I hope everybody's doing well and your business plan, I hope if you don't have one that you have one put together so that it will, again, you don't know, and I think Jeff Green alluded to it last week in one of his presentations. If you don't have a path and a road that you wish to follow this year to achieve the goals you wish, you're not going to get there. So, write your goals out, number one. Number two, write the activities you need to do to achieve those goals. I'm a big believer in that and positive affirmation every day when you get up in the morning. Keep to a routine, make your calls, send out your emails, check your files, and you will be a success. 2018, I was just talking with Jessica, 2018 is going to be a very, very good year for all of us and for all of you. But you're going to have to work. It's not going to be handed to you. So please get out there. I know Jessica's got some great stuff coming out that will be introduced here over the course of the next few weeks. And please lock into that, follow it. I think you're going to be very excited about it when you see it. So today, I am just going to be kind of talking about a number of different things that I have run across here since the first of the year, and I just want to make sure everybody's up to speed on what to do, and if you have questions, again, please go to your broker. That would be Jeff Green in Northern California, Omar Hellman in the LA Orange County marketplace, Mary Jane Morris in Temecula, Murrieta, as well as myself here in San Diego. Feel free to reach out to us anytime by way of email, by way of text, by way of a phone call, and talk to us. Ask us your questions so that we can avoid, hopefully, any issues that may pop up later in your transactions. First thing I want to touch base on is property management. We do not allow it. You are able to assist your clients in finding a tenant as well as turning that tenant over to the homeowner. But in terms of once the lease is executed, you are to step away. I don't want you doing, and Ellis and James does not want you doing property management. I have been involved in property management type transactions before. Believe me, it is a real headache. And inevitably, something goes sideways in terms of the tenant and homeowner relations, and there you are stuck in the middle, and both parties are pointing at you. It's in your own best interest and stress level to keep out of property management. First of all, our E&O insurance doesn't cover it, so you can't do it. But please, if anybody asks you, even a very, very good client, just say, yeah, I can help you find a tenant, and then I'll help you find a property management company. But beyond that, I can't do any more activity. So again, no property management. It's for your own good and for your own stress level, keeping it low. So please keep that in mind. The next thing I want to talk about is the 48-hour rule. I'm noticing that once you have a completed, agreed to transaction, agreed to by the seller as well as the buyer, and you have everybody's signature, again, you have 48 hours to put that transaction and upload that transaction into SkySlope. Please do that. Again, per the contract, per the RPA, we have as brokers 5 days to review that contract. If there is anything we see in that contract that's not legal or is not good for our client, then we can reach out to you so we can discuss it, and the necessary changes that need to take place can take place. So again, 48 hours, load that transaction into SkySlope so your broker has the opportunity and the ability to review it, review the contract, and again, if we see something that's not quite right, we can make the necessary adjustments so that it is right. That would be helpful not only obviously to you, but more so to your client. Modification of terms. Anytime you have a change from the original agreement, you must put in a modification of terms. What that does is that changes the agreement, the initial agreement, from what you agreed to the new aspect of that agreement. So, and the biggest, I think the biggest part of that is if you have a listing and you change the listing price from one point to another point, and this is a listing that you already have in the MLS, you have to have a modification of terms in SkySlope in your file so that we can make reference to the new price change. We can make reference to the change in the terms from the original listing agreement. And that's probably, in terms of what I see, the biggest fall down agents have, is that they don't continue on and they make the change and they get the agreement with the seller, but they don't make the modification of terms. That document requires a seller's signature, so that protects you as the agent too. So it doesn't look like you're just arbitrarily changing the price from one price to another, which could be potentially a legal issue if the seller has not assigned any agreement to that effect. It could get you and everybody into some hot water. So again, modification of terms, it's a protection for you, it's a protection for your seller, and it's required for the SkySlope file. So I thank you for that. Documentation for your file. Again, when we enter into every transaction, we hope everything goes smooth. We hope everybody's happy and that everybody performs to the level they need to perform to. Unfortunately, that doesn't always happen. So what I have seen is where documentation would really ease the clarification of what was said, what was meant. And so when you send out emails, when you send out texts, when you send out any form of communication, even a phone log, even if you call your client and it's all verbal, you should always, when there's a discussion regarding an issue, a change in direction in terms of the marketing or whatever the case might be, always follow up a phone call with written documentation. An email is best. Dear Mr. Seller or dear Mr. Buyer, per our conversation just now, this is what we discussed and this is the direction we're going to go in. And just upload that into SkySlope so that later, if there's a disagreement or a misunderstanding about any of the terms or conditions of your sale or of your listing, again, you're documented. You can say, well, on such and such a date, Mr. Seller, you and I discussed this, and per my email to you, dated so-and-so, here, this is what we discussed. You did not dispute my email, and so it was my understanding that that was what we were doing going forward. So again, document yourself. And when you document yourself in SkySlope as well, so that if we have to go back after the fact, after the escrow closes and a couple months have gone by, nobody's going to remember a verbal conversation or when or how it took place. But they do remember emails because it's in written form. They will remember copies of text. Again, it's in written form. So please document your files, upload that documentation into SkySlope so it's a part of your permanent file. Rejected offers. This is another point that I notice in SkySlope, that we do have a required rejected offer document that can be found in SkySlope. So please go to that document, pull it up, complete it, sign it, and upload it in the rejected file folder. It saves so much of it time and worry. In every case, anytime you get a rejected offer, just a flat-out rejection of the buyer's offer by the seller, always, always, always have them initial page 10 that shows that the seller reviewed the file or the offer, and also have them sign on page 10 just above it that indicates that the seller rejected that offer. That way, if you get challenged after you convey that rejection to the buyer's agent, I, as an agent, when I was in production, I always required that the listing agent send that page to me, just to show me that I could take back to my buyer, hey, listen, they rejected our offer. Here's the proof of that it was presented to the seller, one, and two, that the seller rejected it. It answers all of the questions. It takes the pressure off of you, quite frankly, because it doesn't look like you were trying to scuttle the transaction as well, because you, as the agent, buyer's agent, thought that the offer was too low. So anyway, get that page 10 initialed, get that page 10 signed. That way it all falls back on the seller. It was the seller who reviewed it. It was the seller who rejected it. Lastly, I want to talk about today the trust exemptions. Please read the car form trust advisory. That explains in detail what the trust exemption is and who is qualified for it and who is not. So if you have a trust property sale and that trust and the seller is not the owner, but is a representative of the trust, is the signee for the trust, and that trust advisor has never lived in the property, has no working knowledge of the property, they are exempt. If that trust advisor has lived in the property, has been responsible for renting the property, or has done any remodeling of that particular property, they are not exempt. They have working knowledge of the property and therefore do not qualify for the trust exemption. Again, read the document. It's really clear and it should answer most of your questions. Again, if not, contact your broker so they can help explain in more detail. That's what I have for today. I hope everybody has a great week. And again, it's been a great 2017, and I'm really looking forward to 2018 to be even a better year for production. I wish you all luck and look forward to seeing you all or talking to you at some point this year. Bye.